So, hi everyone, a great day to all of you, especially to our instructor, Sir Edgar. So, today we are going to discuss about the law on common carrier and the air passenger bill of rights. So, before I proceed to the discussion, let me just share something that is connected with what I am going to tackle later on. So let us have first this one. On June 29, 2010, the Supreme Court of the Philippines promulgated a decision in the case of spouses Dante Cruz and Leonora Cruz versus Sun Holidays Incorporation. So it says here that operators of beach resort should offer tour packages that includes ferry services to the guest. That is also considered as a common carrier. So later on, we will find out what was the meaning of the common carrier. So next, we have also another case of spouses Teodoro and Nanette Perena versus Zarate. So the Supreme Court decided that school buses operators should also considered as common carriers in the eyes of the law. So next, I have here one question. Supposedly, it is a question and answer portion during our class, but unfortunately, due to the asynchronous classes, wala akong makakausap. So, ako na lang yung sasagot. But to answer this question, what is your idea or ideas about flight attendant's job description? So, I think kapag tinanong ko to sa inyo during our class, ang isasagot niyo is ang job ng flight attendant is to assist passengers, to assist them to their needs and wants, to lead them to their paths, to their airplanes, something like that. So, yung mga ideas naman na yun is tama. But let us proceed here in the case of Irasugi versus Philippine Airlines. So sabi rito, Supreme Court held that the task of a cabin crew or a flight attendant is not limited to serving meals or attending the desires of sudden change of attitudes of the passengers. So sabi dito, hindi lang daw yung pagsiserve ng foods or pag-assist sa mga passenger ang trabaho ng isang flight attendants or ng cabin crew. So, the most important activity of the cabin crew is to ensure the safety of the passengers and being able to evacuate the passengers during the emergency. So, sabi pa dito, by these developments, Supreme Court decided that all of those travel and tour services as well as the hospitality industries should be well informed or well knowledge pagdating sa mga common carriers. So next, the Civil Codes of the Philippines defines what and who are the common carriers. So the law also imposes the responsibility of the common carrier wherein the failure to observe the same will hold the common liables for damages. So now let us jump up about the basic concept of carrier in general. So the word carrier is very subjective kasi lagi naman natin siyang naririnig eh. And sabi dito, a carrier is a person or corporation who undertakes to transport or convey goods or person from one place to another. So alam naman natin na pag sinabing carrier, okay, para siyang magdadala ng ganito sa ganitong lugar, ganyan. Katulad na lang ng Philippine Airlines, di ba? Philippine Airlines is carrier siya ng country natin. Di ba? Kapag nakikita natin yung mga airplane ng Philippine Airlines, meron silang flag natin sa tail ng airplane. So, kapag sinabi natin carrier, we have two classifications of carrier. It is the private carrier or special carrier, and the second one is the common carrier or public carrier. So let us have first the private carrier. So from the word itself, syempre, private services, private carrier. So sabi dito, without making the activity a vocation or without holding himself or itself out to the public. So meaning to say, yung services mo is pang private lang. Kumbaga yung services ko is pang sayo lang. Kumbaga loyal ka lang sa re-relyan mo ng services mo. For example, ako as a delivery girl and yung isang company na to is hinire ako just for their personal delivery. So hindi ako para tumanggap ng ibang bookings pagdating sa mga pagde-deliver. Kasi, ano na ako meron akong kontrata na sinasabi. It is the private services to them. And then, for example, another example is, meron akong dalawang sasakyan, and I have this friend, Mira. Meron akong dalawang sasakyan, isa is Toyota at isang Civic. And then, yung kaibigan ko is nagsabi siya sa akin na kung pwede daw niyang i-rent yung sasakyan para sunduin yung jowa niyang afam, ganyan. So, pumayag ako, basta gagasan niya yung sasakyan. So, in that way, masasabi ko na private carrier ako kasi yung services na in-offer ko is just private only. It's just for private purposes only. Hindi naman sinabi nung kaibigan ko na si Mira na gagamitin ko yung sasakyan mo or irarent ko yung sasakyan mo kasi ako, magpapasala ako, ganyan-ganyan. So, hindi siya ganon. Kasi yung purpose naman is pang private lang din. It is only for, it is for one particular instances lang. So, ganun lang yung concept ng private carrier. Talagang from the word itself, private. Hindi para buksan mo yung services mo for the public, but only in the private purposes. So, next, it is just the continuation. So, katulad ng sinabi ko kanina, di ba? Umagree ako na hiramin nung kaibigan ko yung sasakyan basta gagasan niya yung sasakyan. So, sabi dito, if one engages the services of a private carrier in a particular instance, then there is an agreement established. This agreement is called contract of private carriage. As such, the law that governs them in the ordinary contract under the civil codes of the Philippines. So, yung private carrier, kapag meron akong napagkasunduan sa isang tao about the services, meron tinatawag na contract of private carriage. So, next, we have the common carrier or public carrier. So, Article 1732 of the Civil Code of the Philippines states that common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or the goods or both by land, water, or air for compensation, offering their services to the public. So, specifically, from the word itself, public carrier or common carrier. So, next we have here a few questions. So, supposedly, i-ask ko din siya during our class, but wala nga tayong classes. So, question number 1, do you consider those following enumerations as common carrier? So, meron tayong 5, which are bus, train, airplane, vessels, and jeep. So, answering this question, if kino-consider ba daw sila as common carrier, so the answer po is no. So, kung mapapaisip ko yung, bakit hindi sila common carrier? Itong 5 to, nakakapag-transport naman sila ng mga products, o mga goods, at ng mga tao. So, bakit hindi? So, mamaya malalaman natin kung bakit. So, next, we have the question 2. Are the following enumerations are common carrier? So, meron tayong 5 ulit. Philippine Airlines, Land Rail Transit Authority, Sulpicio Lines Incorporation, Florida Bus Incorporation, and LBC Corporation. So, ang sagot naman dito sa pangalawa, kung considered sila as common carrier, is yes po. So, bakit? Bakit ba yes yung pangalawang question at yung unang question ay hindi sila common carrier? Kung mapapaisip ka, common carrier yun. Bakit hindi, di ba? So, balikan natin yung slide or yung meaning nung common carrier or public carrier. So, sabi dito, common carriers are those persons, corporations, firms, or association engaged in the business of carrying or transporting passengers or the goods. So, balikan natin yung number 1. So, di ba sabi dito, do you consider those following enumerations as common carrier? Ito yung mga bus, train, airplane, vessels, and jeep. So, hindi po sila common carrier because they are neither person nor corporations or firms, but they are just simply modes of transportation. So, hindi po siya common carrier because lang sila, modes of transportation lang sila. So, next, number 2, kung i-observe nyo naman itong mga nakalist sa 1 to 5, so sabi dito, di ba, are the following enumerations are common carrier? So, meron tayong Philippine Airline, Land Rail Transit, Florida Bus Incorporation, LBC, and Sulpicio Lines. So, the answer is yes. Bakit? Kasi sabi nga, di ba, sa meaning ng common carrier, these are persons, corporations, and associations. So, ano ba yung mga Philippine Airline? Ano ba yung mga land rail transit na yan? Di ba mga corporation sila, mga tao sila na nag-engage in business na open for public. So, may tanong pa dito sa baba is, do they engage in the business of carrying or transporting passengers or goods? Yes, they are. Pangalawa, do they offer services to their public? And last is, it is open for compensation. So, yes po ang sagot sa tatlong ito. So, napakadali lang naman niyang intindihin. Pag private, private to private. Kapag public carrier, public to public, di ba? So, ganun lang po siya.
So, yung next naman is contract of public carriage and transportation. So, dito, ang sabi is, when engaging the services of the common carrier, there is a contract that is established. The contract is called contract of carriage or contract of public transportation. The parties herein are the passenger and the common carrier. So, dito naman, ini-state na ito, dalawa. Is either the private sector or the private carrier or the public carrier. So, sabi dito, merong mga common carrier talaga na sila yung nagta-transfer ng goods and services from one place to another. So, meron ditong mga some companies na sila na yung mismong mag-deliver nun sa bahay nyo. Depende sa napagkasunduan yung price and willing kayong magbayad sa price para ma-deliver din kung kailan or anong time na gusto nyo or period of time na gusto nyo ma-receive yung goods nyo. And meron ditong quote na sinasabi, how could there be a contract when in the first place there was no document signed when boarding the vehicles of the common carrier? So sabi dito, remember that the common contract is meeting of the minds and not the paper. So hindi lahat is about sa papers, sa documents, sa mga signs na binibigay natin sa mga carrier. Bagkus, since we already paid for that, and responsibility na nila i-deliver yung goods sa atin ng maayos. So, hindi lang siya about sa papers and documents, but instead, about din sa responsibility ng isang carrier na i-deliver yung goods and services from one place to another sa napag-agree nilang both side na price and fee na dapat bayaran. And sa time na dapat ma-receive ni receiver or consumer. So, sabi rin dito, lastly, if the common carrier failed to perform its obligation, the passenger can sue the former for breach of contract and will be held liable for damages. So, syempre, since nagbayad tayo ng maganda, nagbayad tayo ng tama, at we both agree sa payment na binase natin, syempre, kung na-receive natin siya na sira, or lost, or something na hindi talaga siya maganda, syempre liable yung specific company or yung carrier na palitan yung mga damage or losses natin. And one thing good sa contract of public and carriage or transportation na to, kasi dito mas mapapadali nating ma-receive yung mga goods and services na kailangan natin. Especially if may mga need tayo, may mga time tayong hinahabol. This will help us more lessen the hassle as well.
Responsibility of a common carrier. First is Civil Code of the Philippines, Article 1733. Common carriers, from the nature of their business and for no reasons of public safety, are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them, according all circumstances of each case. So, yung common carriers, example nito is yung mga incorporations, organizations, associations, ito yung mga nag-handle ng business. And ang ginagawa dito is sila yung in charge or nagse-secure ng public safety ng mga passengers and yung mga goods that being transported. Next is Article 1755. Common carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons with a due regard for all the circumstances. So, dito naman, yung mga common carrier, ang main focus nila is yung safety ng passengers lang. So, talagang iniingatan nila, nagpo-provide sila ng human care and sinesecure nila maigi yung kapakanan ng mga passengers nila. Next is Article 1756. In a case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence. So dito sa article na to is pag may nangyaring masama sa passengers mo, ikaw yung magte-take responsibility and ikaw yung may kasalanan dun. Kasi dapat mo i-ensure yung safety ng mga passengers mo and kaya kailangan mong i-observe lahat bago ka tumanggap ng mga passengers and tsaka kayo mag-transport. Clearly, a common carrier is obliged to observe utmost diligence or extraordinary diligence. Utmost diligence is the highest degree of care. So, kung masipag ka na i-check lahat bago kayo mag-start, bago mag-operate yung isang business, bago kayo mag-transport ng goods or ng passengers, doon pa lang mapapakita mo na kung paano mo pinapahalagahan hindi lang yung business mo, kundi yung mga tao or yung mga goods na yung mga services na i-offer mo. When should the common carrier commence to observe extraordinary diligence? Of course, if its goods are carried, if passengers are carried.
Next, when does the contract of public carriage cease? When we say cease, ito yung pagtigil o pag-stop ng isang bagay o contract. It has been recognized as a rule that the relation of courier and passenger does not cease at the moment the passenger alights from the carrier's vehicle at a place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or reasonable opportunity to leave the carrier's premises. Sinasabi dito na yung relationship or yung ugnayan ng passenger and carrier ay hindi agad tumitigil pagbaba ng passenger sa sasakyan ng carrier. For example, sumakay ka ng MRT or LRT. Pagbaba mo ng train, tapos naglalakad-lakad ka pa lang or may binili ka sa loob ng station ng train na yon, still considered ka pa rin as passenger. Kasi nandun ka pa sa kinatatayuan mo or may binili ka pa dun sa sakop ng courier. Next, and what is reasonable time or reasonable delay within this rule is to be determined from all the circumstances. So, ganun din, for example, sumakay ka ng MRT or LRT para pumunta sa work mo or sa school, tapos pagbaba mo, imbis na dediretso ka na, mag-e-exit ka na dun sa premises ng station, nagkaroon ng delay kasi biglang tumawag kuwari yung kaibigan mo or yung kamag-anak mo na yung kasamahan mong passenger kanina sa una mong sinakyan na train ay may nangyaring masama. For example, na baril. So, para hindi mag-alala yung yung kaibigan mo or yung kamag-anak mo, nag-decide ka na sumakay ulit ng train para pauwi, para maibsan yung nila, yung pag-alala. So, dahil doon, nag-continuous yung pagiging passenger nung carrier na yon. Balik tayo sa tanong na, when does the contract of public carriage cease? So, mapuputol o titigil lang yung ugnayan ng passenger and carrier pag yung passenger mismo ay wala na sa sakop ng carrier or yung premises ng carrier. For example na nga dun sa train, kung sumakay ka ng train tapos umalis ka na talaga, wala ka na dun sa sakop ng ng station na yon, ibig sabihin tumigil na yung contract nyo nung public carriage at ikaw na passenger. Also, here we have 3 example of illustrative cases para mas malinawan o mas maintindihan nyo pa yung topics na sinabi namin kanina.
Next is the illustrative case of La Mallorca versus Court of Appeals, GR number L20761. So, yung facts dito sa case na to is, noong December 20, 1953, at about noon time, Mariano Beltran, or Mariano for short, his wife, together with their minor daughters Milagros, Raquel, and Fe, boarded the Pambusco bus owned and operated by the La Mallorca. The bus is bound for Anao, Mexico, Pampanga. At the time, they were carrying with them 4 pieces baggage containing their personal belonging. At about an hour trip, the bus reached Anao where it stopped to allow the passengers bound thereof, among whom were Mariano and their children, to get off. Mariano, then carrying some of their baggage, was the first to get down the bus, followed by his wife and his children. Mariano led his companions to a shaded spot on the left pedestrian side of the road, about 4 or 5 meters away from the vehicle. Afterwards, he returned to the bus in controversy to get his other belonging, the bayong, which he had left behind, but in doing, his daughter Raquel followed him unnoticed by her father. So, yung issue dito is the contention of the common carrier is the child was no longer its passenger, correct? So, ang ruling is no. It has been recognized as a rule that the relation of carrier and passenger does not cease at the moment the passenger alights from the carrier's vehicle at a place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or a reasonable opportunity to leave the carrier's premises. And what is a reasonable time or a reasonable delay within rule is to be determined from all the circumstances.
So, next example of illustrative case, we have spouses Dante Cruz and Leonora Cruz versus Sun Holidays Incorporated, GR number 186312, June 19, 2010. Facts: Ruelito Cruz and his wife contracted a package tour with Sun Holidays Incorporated. The latter owns and operates Beach Island Resort and a boat named MB Coco Beach III for their guests. The package tour includes the transportation of the couples from Port of Batangas to Beach Island Resort in Puerto Galera and vice versa. The couple stayed in the said resort from September 9 to 11, 2000. On September 11, 2000, as it was still windy, Ruelito and his wife boarded the boat MB Coco Beach III of Sun Holidays to ferry them back to Batangas. Shortly after the boat sailed, it started to rain, and as it moved farther away from Puerto Galera and into the open seas, the rain and wind got stronger, causing the boat to tilt side to side. The waves got more unwieldy. After getting hit by 2 big waves, which came from after the other, MB Coco Beach III capsized, putting all passengers, including Ruelito and his wife, underwater. As a consequence, 8 passengers died, including Ruelito and his wife. The parents of Ruelito filed a case against Sun Holidays Incorporated for damages at breach of contract of common carriage, Sun Holidays denied that it is not common carrier. It raises the defense that while they own a boat, the same is not available to the general public but only for the resort guests and crew members. So the issue here is Sun Holidays Incorporated a common carrier? The ruling, the Supreme Court held that Sun Holidays Incorporated is a common carrier. Its ferry services are so intertwined with its main business as to be properly considered ancillary thereto. The constancy of its ferry services in its resort operations is underscored by its having its own Coco Beach boats. And the tour packages it offers, which include the ferry services, may be availed of by anyone who can afford to pay the same. These services are thus available to the public. And this ruling, pinapatunayan siya ng Article 1732. It makes no distinction between one whose principal business activity is the carrying of the persons or goods or both, and one who does such carrying only as an ancillary activity or a sideline. Article 1732 also carefully avoids making any distinction between a person or enterprise offering transportation service on a regular or scheduled basis and one offering such service on an occasional, episodic, or unscheduled basis. Neither does Article 1732 distinguish between a carrier offering its services to the general public, the general community or population, and who offers services or solicits business only from a narrow segment of the general population. So indeed, Sun Holidays Incorporated is a common carrier.
Follows such a case of spouses Chodoro and Nanette Porreña versus spouses Nicolas and Teresita Zarate, GR number 167917, August 29, 2012. So facts, the Porreñas were engaged in this business of transporting students from their respective residences in Parañaque City to Don Bosco in Pasong Tamong, Makati City, and back. In their business, the Porreñas used a Kia Sears van, which had the capacity to transport 14 students at a time, 2 of whom would be seated at the front beside the driver, and the other at the rear, with 6 students on the other side. They employed Clemente Alfaro as driver of the van. In June 1996, the Zarates contracted the Porreñas to transport their son, Aaron, to and from Don Bosco. On August 22, 1996, as on previous school days, the van picked Aaron up around 6 a.m. from the Zarates residence. Aaron took in his place on the left side of the van near the rear door. The van with its air conditioning unit turned on and the stereo playing loudly ultimately carried all the 14 students, riders on their way to Don Bosco. Considering that the students were due to Don Bosco by 7:15 a.m. and that they were already running late because of the heavy vehicular traffic on the South Superhighway, Alfaro took the van to an alternate route at about 6:45 a.m. by traversing the narrow path underneath the Magallanes interchange that was then commonly used by Makati-bound vehicles as a shortcut to Makati. So, the issue is whether or not defendant spouses Porreña are liable for the breach of the contract of carriage. So ruling is yes, because Perennials operated as a common carrier and that their standard of care was extraordinary diligence, not the ordinary diligence of a good father of a family. Although, in his jurisdiction, the operator of a school bus service has been usually regarded as a private carrier primarily because he only caters to some specific or privileged individuals and his operation is neither open to the indefinite public nor for public use. The exact nature of the operation of a school bus service has not been finally settled.
So next, common carriers are liable for the acts of their employees. Common carriers are liable for the death of or injuries to passengers through the negligence or willful acts of the former's employees. Although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. So dito, may pananagutan yung common carriers sa pagkamatay or pagkakaroon ng injury ng passenger kung kahit na hindi sinasadya ng empleyado nila na mangyari yun sa passenger. At lalo na may pananagutan yung common carriers pag sinadya o may kapabayaan yung empleyado nila sa passenger. This liability of the common carriers does not cease upon the proof that they exercise all the diligence of a good father of a family in the selection and supervision of their employees. Ito, patunay ito na yung mga common carriers, ginagawa nila yung makakaya nila para makapili ng mga empleyado na sisiguraduhin yung kapakanan ng mga passenger. For example na lang ng common carriers are liable for the acts of their employees. Sa airplane, di ba may mga flight attendant doon? Pag yung flight attendant may ginawa sa hindi maganda o trinato ka ng hindi maganda, yung employer ng flight attendant or yung common carriers na tinatawag natin ay liable sa action na ginawa ng flight attendant sa'yo. And another example, mga usual na nasasakyan natin dito sa land. For example, nag-tour kayo ng family mo, tapos yung sinakyan nyo na bus, yun kasi yun yung kasama ng transportation sa tour package nyo. Yung driver ng tour bus nyo ay ninakawan yung isa nyong kasama na tourist. Yung mismong tour bus operator, yun yung liable sa action na ginawa nung driver. Kasi yung driver ay kasama o galing sa organization ng tour bus operator.
Fortuitous events may exempt the common carrier from liability. Number 1, not all the times the common carrier is always liable for one if the common carrier was able to prove that it exercised extraordinary diligence to protect its passenger. The common carrier will not be held liable. So dito, pag napatunayan na talagang nag-ingat, talagang iningatan ng carrier yung passenger nila, yung goods nila na dinelivered, hindi liable or hindi mananagot yung carrier doon sa nangyaring yun. Second, if the cause of the injury or death of a passenger is due to fortuitous events, then the common carrier may be exempted from liability. Ito naman, kapag ka naman yung cause ng injury or pagkamatay ng isang passengers is hindi sinasadya or nagkataon lang, hindi responsibility ng carrier yung nangyari. So, hindi siya magte-take ng any liabilities or what.
Next, we have the Article 1174 of the Civil Code. It provides that no person shall be responsible for a fortuitous event which could not be foreseen or which, though foreseen, was inevitable. Sinasabi dito sa Article 1174 na walang sinumang tao ang mananagot sa mga pangyayaring hindi inaasahan o hindi natin maiiwasan. But, If what have been transported are goods, the law provides that common carriers are responsible for the loss, destruction, or deterioration of the goods. So pag yung common carriers, yung mga tinatransport na nila is mga goods, may responsibility sila sa loss or destruction ng goods na yon, unless the same is due to any of the following causes only. The first one, yung natural disaster or yung mga calamities katulad ng pagkabaha, earthquake, storm. Second one, we have act of the public enemy in war, whether international or civil war man ito. Act of omission of the shipper or owner of the good. So, syempre, wala nang responsibility yung common carriers pag yung mismong owner na o yung seller yung may pagkukulang sa goods na yon. Next, pang-apat, the character of the goods ay may defective siya or yung packaging ng goods ay hindi maganda or hindi siya pasok sa quality ng goods na yon na itatransport. The last one, order or act of component public authority. So, hindi na responsibility ng common carriers yung pagkakaroon ng order ng isang public authority sa isang specific na lugar na yon.
The Air Passenger Bill of Rights of the Philippines. This law, promulgated by virtue of the joint DOTC to DTI Administrative Order Number 1, Department of Transportation and Communication to Department of Trade and Industry on December 10, 2012. So, itong batas na ito is nagproprotekta sa mga karapatan at interes ng mga pasaherong bumabiyahe gamit ang eroplano ng Pinas. Ang hangad ng batas na ito is magkaroon ng pantay at patas na pakikitungo o pagtrato sa mga passengers in case na magkaroon ng flight delays, cancellation of flights, at saka disruptions.
These three rights are the main priority of the passenger na layuning mabigyan ng proteksyon ang mga pasahero para sa kanilang binayaran for their travel. Una ay karapatan nilang makatanggap ng right information for their purchase to ensure na tama yung important details na pinabayaran nila, tulad na lang ng flight schedules, fares, fees, at may terms and conditions na mapagpapasyahan ng airlines and the passenger para hindi magka-conflict both parties. Pangalawa, karapatan ng pasahero na makatanggap ng buong serbisyo sa mga binayaran nila. Dahil nga nag-avail si client, they have the right na mag-expect sa services sa loob ng airline ayon sa ibinigay na buo ni passenger at ipinangako naman ng airlines base sa napagkasundo nila, tulad na lang ng amenities sa loob ng aeroplano at benefits sa biniling ticket. Pangatlo, kung may mga changes upon agreed services, may karapatan ang mga pasahero sa kompensasyon o alternatibong services if sakaling magka-problema, tulad na lang ng delayed flight, denied boarding, rebooking fees. Dapat ay covered expenses na ito ng airline for the inconvenience if fault nila. At nakadepende naman sa binayaran ng passenger ang ibibigay na service or alternative compensation ang ibabalik ng airline for transparency and fairness for the rights of the passenger.
Compensation for delayed, lost, and damaged baggage. Checked-in baggage has been offloaded for operational, safety, or security reasons. The following rules shall apply. The first one is, the airline must inform passengers as soon as possible if their baggage has been offloaded. Ang bawat airline ay responsible na ipaalam agad sa mga pasahero kung na-offload ang kanilang mga bagahe to inform them the situation of their baggage. And then the second one is the air carrier should make the appropriate report and give the passengers a copy their baggage details and ensures the transparency and accountability on the part of the carrier. Mahalaga din bigyan ng air carrier yung mga passenger ng baggage details para kung sakaling magkaroon ng problema, they have the documents or proof of their personal baggage. And then the last one is compensation of 2,000 per day of delay is required for every 24-hour period starting 1 hour after the passenger's flight arrival.
And lastly is compensation in case of death or bodily injury of the passenger. For international flights under the 1966 Montreal Intercarrier Agreement involving the USA, the liability limit for passenger death or injury is $75,000 inclusive of legal fees. However, if a state allows separate legal fee awards, the limit is $58,000 excluding legal fees. Domestic flight compensation follows the international convention's stipulated amount but in peso. So, although air transport is one of the safest modes of transport, hindi pa rin natin may iwasan or masasabi ang mga mangyayari like air accidents, that cause death or bodily injury sa mga pasahero. Pati na rin yung air crashes may lead to even more tragic consequences. In light of this, dapat lubusang isaalang-alang ng mga air carrier how to compensate passengers or yung mga kamag-anak nito after the air accidents. To address naman this issue, the first thing to be considered is which laws apply. In the case of international flights, the rules of the relevant convention shall apply as to compensation for death or bodily injury sustained by a passenger in the contract of carriage. In the case of flights, domestic flights naman, the passenger shall be entitled to the compensation subject to the provision of the contract of carriage or the compensation as provided in the provision of the relevant convention in its Philippine currency equivalent, whichever is higher.
And that's all, everyone. We hope that you have learned something about our report. Thank you for listening.